Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're breaking down high-stakes fusion verdicts. And so this is nationwide, and when we say fusion, we're referring to either a cervical, which is the neck, spine fusion, or a lumbar spine fusion. And just briefly, for those that don't know how it works, if somebody has a herniated disc, what it means is in the spine, this is a model of the lower back, you could have a vertebra, but you also have a disc, and the disc is like a cushion between the bone, between the vertebra. And if from a crash, let's say, or a fall, this disc explodes and the liquid inside the disc is now leaking out, which is the red part, and it's touching the nerves, that's a herniation. And one of the treatments, if everything else fails, they might try pain management, they might try other options, but if everything else fails, they might have to remove the entire disc and put in an artificial space in there and then put metal, like a plate with screws going into the vertebra, and that's a fusion. And the idea is that the area will now be fused, the bone will kind of grow together, and you'll have that space, artificial cushion. And then you won't have as much bending anymore, but at least you won't have the pain. And so that's the fusion procedure. And oftentimes it is a common surgery, unfortunately, that people have to have done after a car crash, after a truck accident, after a ceiling collapse, or a trip and fall, a premises case. So let's break down the most recent fusion verdicts. And I'm using one of the databases, like we have access to LexisNexis, Verdict Search, and some of Westlaw, some of the other databases. So the one I'm seeing most recent is actually from August 15th, about a month ago, August 15th of this year. And it's from Los Angeles, California. And what happened here is that a customer was injured after backing into an unattended pallet jack. So let's get into this case. Let's see what this is all about. It was a woman who was 65 years old. Her name is Henrietta. On January 15th of 2020, she went to the Home Depot in Monterey Park with her fiance to look for wood flooring for their bedroom. And while shopping, they looked up toward a flooring display at the end cap and walked over to it. And after about 2 minutes, she took a couple of steps back while still looking over the display, and she tripped, falling backwards. And the fall was captured on Home Depot's surveillance video. And so she sued the owner of the store, which is Home Depot, and she alleged premises liability due to a dangerous, unsafe condition, as well as negligent maintenance. And before she fell, they were browsing the aisles, and they didn't know that a Home Depot worker left a manual pallet jack in a main customer aisle 5 feet away from the end cap where the flooring was displayed, a couple of aisles away from where the plaintiff and her fiance were browsing at that time. And so the plaintiff's attorney argued that the pallet jack was a dangerous condition. During discovery and trial, they noted that the pallet jack had been in the customer aisle, left there by a Home Depot worker, unattended, untouched, unmoved, and it was there for 15 minutes before the plaintiff fell. And according to the plaintiff's attorney, this was a violation of Home Depot's safety policy and procedure, as well as industry standards. So that's an important point to note, that when you're doing a case like this, what you want to first do is ask Home Depot or whoever you're suing, send me a copy of your policies in terms of safety. You review those policies, and then if you can prove that the facts of your case, they violate their own policy, well, then you have a strong argument that, wait a minute, this is unsafe because they're violating their own policies, their own safety rules, right? And in the same way, you can hire an expert that can talk about industry standards. What's the industry standard for all big box stores, whether it's Home Depot or Walmart or Costco? And then, can you leave a pallet jack like that in a customer aisle? And, and then you have an expert say no, because if somebody's looking like she was, right, at flooring, you might want to take a step back to see how the flooring looks from a little bit more of a distance. And you don't know there's this thing behind you that's a tripping hazard. And they're also saying that plaintiff's attorney also noted that other workers, other employees of Home Depot acted negligently because they walked past this pallet jack 6 times before the plaintiff fell, but they didn't do anything about it, right? So if they see it standing there and they know that's a violation of their custom and practice, their safety rules, they could have alerted someone, called, gotten somebody to move it, but they didn't do that. So it was there for a long time, and I guess the video showed 6 other workers walking. And at the deposition of the worker who left the pallet jack in the aisle, he admitted he had not remembered why he left it unattended or when he planned to return it. And at trial, the plaintiff's attorney noted that the employee changed his story and said that he left it there because he was in the process of doing the store closing procedures, even though the fall occurred at 6 p.m. and the store was not set to close until 10 p.m. And later, after a break at trial, the plaintiff's attorney noted that the employee testified that he reviewed the surveillance video several times and believed he was attending to a customer or another sales associate based on the pace he was walking in the video. So yeah, the pallet jack was behind the plaintiff when she took steps back. The plaintiff and her fiance testified at deposition and at trial that they never saw the pallet jack before she fell. And the plaintiff's counsel noted that the incident report filled out by the assistant manager stated, customer took a step back and did not realize a pallet jack was behind her and tripped over it. And that's also an important point because you see, when they make these incident reports, they write them in a way to make the customer at fault. They're not going to say, you know, we left the pallet jack, it should be at a customer aisle. No, they're going to say, customer fell and she didn't realize, right? She didn't realize. Like, she should have realized. She should have eyes in the back of her head and realize that this thing is here. See, so they're always writing it from a way to kind of minimize liability for them. And I think they're trained to do that because I see that in a lot of cases. And the plaintiff's attorney noted that the defense expert in safety admitted at trial that prior to his deposition, he changed his opinions after he spoke to the defense expert in human factors and defense counsel. And during the trial, this expert was impeached several times. And the plaintiff's attorney also added that the defendant's expert in ergonomics, as well as human factors, only opinion was that a reasonably attentive person paying attention to their surroundings would have seen the manual pallet jack in the aisle and would have avoided it. But, you know, again, like, how are you going to see it if it's behind you? And on cross-examination, plaintiff's counsel noted the expert admitted that he had not known what the plaintiff, Henrietta, was seeing, perceiving, or thinking solely based on the video. And he also testified that it was not possible to make the world safe for people stepping backwards, despite Home Depot's training videos, which trained their workers to look behind them before they step backwards. And the defense counsel contended that the manual pallet jack was, quote unquote, in use, and therefore had not violated Home Depot's safety policies and procedures or industry standards. However, according to the plaintiff, this conflicted with the defense's own safety expert's admission at trial that whether the pallet jack was in use or not, it should have been put away as soon as possible. And the defense counsel brought into trial an exemplar manual pallet jack for the jury to see. And so the injury, let's get to the injury. So the plaintiff, Henrietta, she complained of back pain at the scene of the fall. She claimed the accident caused 2 new disc herniations, L2, L3, and L3, L4, and that a degenerative disc at L4, L5 became symptomatic and caused increased fluid in her facet joints, which was evidenced in the February 2020 lumbar MRI. So an ambulance took her to a medical center. She was diagnosed with back contusions, prescribed pain medication, and was advised to follow up with her primary care physician. And she was basically referred to rehab by her attorneys, where she started chiropractic. And she claimed that her lower back pain had started to radiate down to her right leg. So that's known as radiculopathy, where the pain in the back is traveling or radiating down to the leg. That means the nerves are impinged. That makes it more serious. And so she claimed she had an epidural injection. It gave her 85% relief, but the pain came back. She had a second epidural, and she ultimately needed an L4, L5 lumbar discectomy and fusion that failed. And after that, she underwent a third epidural, where she claimed initially provided her with 45% relief. And then she had a trial and permanent spinal cord stimulator, which were performed by her expert and treater in physical medicine. And with respect to her medical history prior to the fall, her counsel noted that she had an X-ray taken of her lumbar spine back in 2008. And the report said the indication was back pain and that the impression was multiple degenerative changes at L5, S1, and spondylosis. And so in 2014, she visited her primary care physician, where she tried to reach for something and sprained her back and fell backwards had back spasms. And she was diagnosed with a lumbar sprain strain. So this was, I guess, 2014. So this was before this incident. So she had some other, pre-existing injuries, but didn't seem like they were too serious, just some sprain strain. The defense argued that all of Henrietta's treatment was attorney directed and that her treatment drastically increased after her attorneys referred her to this rehabilitation center. And the defense, through their expert in orthopedic surgery, also argued that all of Henrietta's injuries were pre-existing and caused by degeneration. As a basis for their argument, they relied on her prior medical treatment, all the stuff from 2014. And so the plaintiff's attorney said that the defense expert orthopedic surgeon admitted on cross-examination that he had given the opinion to a jury several times in the past that a person with those complaints and findings would have their symptoms resolved within 4 to 6 weeks. And so, what was the result? So the jury found that Home Depot was negligent and that its negligence was a substantial factor in causing Henrietta's harm. And the jury awarded $6,626,602.98. And it was broken down as follows: $653,160 for past medical costs, $973,442 for future medical costs, $3,250,000 for future pain and suffering, $1,750,000 for past pain and suffering, for a total of $6.6 million. So it was the demand, prior to this verdict was $2 million. The offer was $500,000. The trial took 12 days. The jury deliberated for 3.5 hours. And after the trial, plaintiff's attorney added that with interest, penalties, and costs, the total verdict would be over $7 million. And plaintiff's counsel has been informed that this is the highest verdict in a trip and fall case against Home Depot in California. The next case is right here in New York. And it was actually a settlement. It was also a trip and fall. The way that they have this case titled is that plaintiff alleged raised sidewalk caused a fall. And so let's get into the facts of this one. The trial happened on July 30th of 2025. And the incident happened on April 19th of 2019. The plaintiff, his name is Marcos. He was in his late 40s and a sanitation worker. And he's working when he tripped and fell on a raised sidewalk in front of a home on Bronx River Avenue in the Bronx. And he claimed that he hurt his shoulder. So he sued the city and the property manager, who was an individual. And he alleged that they were negligent in the maintenance and repair of the premises and in allowing a dangerous condition to exist. And summary judgment was granted against the city. So he got a judgment as a matter of law that they were negligent. And according to the plaintiff's attorney, the city had been given prior citations about the raised sidewalk. The defense argued that the plaintiff, Marcos, was partially at fault for not seeing the raised sidewalk. And so the injury was bulging discs at C4-5, C5-6, a disc protrusion, which is similar to a herniation, and that's C6, C7, a disc herniation at L4, L5, cervical radiculopathy, a right labrum tear, a slap tear, a torn right rotator cuff, and a shoulder sprain. So he underwent an anterior cervical discectomy and fusion at C4 through C6, so C4 to C5, C5 through C6. And this was done in October of 2019, just a few months after the incident. And he also had an arthroscopic surgery repair to the shoulder in January of 2021. He had physical therapy, he didn't return to work, he claimed to still be in pain. And the defense argued that the neck injury was not related to the fall because the plaintiff did not report neck pain until a few months after the accident. And the parties agreed or negotiated a pretrial settlement, and New York City agreed to pay $2.25 million. And so that was the settlement. Okay, so pretty good result, $2.2 million for a two-level fusion and a shoulder injury. Now, the third case is out of Texas. This is from Dallas. Here's a case where the way they titled this case is that the plaintiff claimed that the defendant ran a red light causing a crash. And this is Dallas County District Court. It also happened July 30th, the trial did, July 30th of 2025. This was a May 13th, 2024 incident where the plaintiff, his name is Nicholas, was driving in Dallas while crossing an intersection that was controlled by a traffic light. He broadsided a vehicle driven by the defendant, and he claimed that neck injuries and headaches. And he sued the defendant for negligence, alleging that she ran a red light. And he also claimed that he waited until his light was green before proceeding, and that the defendant then ran her light and caused the crash. And the defendant argued that plaintiff caused the crash by accelerating into her side as soon as the light changed instead of waiting until the intersection had cleared. Nothing was obstructing his vision or distracting him, and he should have kept a better lookout, or waited, or at least should have tried to brake or swerve. And that was the defendant's argument. Now, the injury was a pain management clinic. There was an annular tear in the cervical spine, headaches. A pain management clinic, there were 2 injections, one of which was a rhizotomy. And then 3 months after the crash, he was referred to another pain management clinic for a second opinion, and he had 2 more injections there. And then 9 months after the crash, he had a cervical fusion. And there was a life care plan, subsequent fusion at adjacent levels, because if you have a fusion at like one level, it's medically known that within 10 or 15 years, you're going to need a fusion at the level below and the level above. So that was part of the life care plan. So he sought $377,000 for past medical expenses, $650,000 for future medical expenses. He also claimed past and future physical pain, past and future mental anguish, and past and future physical impairment. Now, the defense argued that the plaintiff sustained minor whiplash only, nothing else. None of his treatment was medically necessary, and that if it were, the reasonable charges would have been around $50,000, not these high astronomical numbers like 377 and 650 for the future. And the defense also noted that the plaintiff was referred to both of the pain management clinics by an attorney. You see, they did that in the last case too. They like to do that. They like to say like, oh, the attorney is referring you to these doctors, kind of make it seem like if you didn't have an attorney who was greedy and trying to win a lot of money, then you wouldn't have gone to this. So it's kind of like, but so you want to be careful there. Like as an attorney, some people just say, look, I'll give you like 3 or 4 doctors, you choose where you want to go. Then it's not really an attorney referring you to a doctor. It's just an attorney giving you options, and then you're finding the doctor on your own. Some attorneys just embrace it and say, yeah, because that's my job. I'm a civil justice trial attorney. So if my client, my patient needs, a doctor, I'm going to give them a good doctor, an independent doctor, and they just embrace it and they just own it and they just admit it, right? Front it. And that's another option. So yeah, that's usually a good way to deal with it. You definitely don't want to hide it and don't want to just say, yeah, my attorney referred me without explaining it, right? Like a first option where you give many options, then it's not really attorney referred. It's just, attorneys basically being like Google, right? Or like the Yellow Pages, and they just pick somebody. Or the second option where the attorney embraces it, but you don't want to just say nothing about it, because then the defense is going to jump on it, and then it's going to seem like the attorney's trying to orchestrate almost like a false case, and that's not going to be good for the plaintiff. So anyway, what happened here was that the jury found that the defendant was liable for the crash. Specifically, it found that her negligence and not the plaintiff's proximately caused the crash. But in terms of the damages, they found that the plaintiff's damages totaled $150,000. So very low damages for, fusion. In New York, like you've seen, it's 2.2 million. In other cases, we've seen even like 6 million in California just now. And based on past videos I've done, usually goes into the millions. The way it was broken down here was that the past medical costs were $131,500. The future medical costs were only $10,000. The past physical impairment was $8,500, and that was it, right? So there was no other category like mental anguish or physical pain and suffering that got any money, and so the total was $150,000. And the demand before this verdict, before the trial, was $800,000, and the offer was $580,000. So the offer was much higher than the actual verdict. So I guess, in this particular case, and the jury vote, by the way, was 11-1. So in that particular case, it would have been better to take the offer of 580 than to do the trial and get 150. But, you never know with these cases. Like you see, they run the gamut. It's kind of like similar injuries. Somebody has a fusion, gets 6.6 million. We've even seen much higher than that. Someone else, and they only get, 150,000. And sometimes people get zero, or sometimes 20,000, or ridiculously low numbers. Okay, the next case is also a rear end crash with an injured driver, and it's out of New Jersey in Morris County. And what happened here, this was July 25th. The trial was July 25th of 2025. Let me get into the facts here. I see the experts. There was a neurosurgeon, and there was also an orthopedic surgeon for the plaintiff. This incident happened on April 27th of 2023. The plaintiff was 22 years old, and she was driving south on a county road in Randolph when the rear of, Renee, I guess it's a man named Renee, when the rear of his sedan was struck by the front of a trailing passenger van driven by the defendant. And so he claimed neck injuries, and the passenger also claimed back injuries. He had a passenger. And in separate suits, they both sued the defendant, and the lawsuit basically alleged that the defendant was negligent in the operation of a vehicle. The court granted the plaintiff's motion for summary judgment on liability, leaving only the issue of causation and damages to be determined, because it was, like I said, it was a rear end, so there wasn't really much to the liability. Rear ends are usually summary judgment. So the injury was that they both presented to a medical facility. They were treated and released. One of them, Renee, he was ultimately diagnosed with lumbar radiculopathy and aggravation of pre-existing herniations at L4, L5, as well as L5, S1. And then the passenger, she was diagnosed with a herniation at the cervical intervertebral disc, C5, C6, and a bulging at C4, C5. And so there was spinal manipulation, electrical muscle stimulation, physical therapy, chiropractic, 2 epidurals for the gentleman. And then there was a neurosurgeon who determined that one of them, I believe the lady, she required a hemolaminectomy with a partial medial facetectomy and foraminotomy. So she had a pretty, advanced surgery. L4, L5, and L5, S1. So yeah, so I think she had a lot of treatment. And then the gentleman probably didn't have as much treatment. And then the other passenger actually also had a discectomy infusion at C5, C6. It just tells you later on. And then she was also at risk for future complications and things like that. So anyway, the parties negotiated a pretrial settlement. The defendant's insurance agreed to pay the passenger, right, who was 46 years old, the lady. Her name is Anna. It agreed to pay her $325,000, and it agreed to pay Renee, the gentleman, $300,000. And this was a policy that had $2 million in coverage. So the total result was $625,000, and there was no trial. So, not terrible. I mean, there's some money involved, but $300,000, and each of them had a fusion. I would say that's also on the low end, but this is somewhere, I think, in South Jersey, maybe a conservative venue. So you see like the difference, like in Los Angeles, 6.6, New York, Bronx, 2.2. And then when you get into like Dallas, you're seeing 150. You get into like New Jersey, maybe somewhere South Jersey where it's more conservative or rural, you're seeing 300 settlement for fusions. And then, let me just go quickly over some of the other cases. There's a lot of cases because we're looking at all the fusion cases, nationwide. So there's like probably 5,000 cases. So we can't obviously do all of them, but we could just do a little bit of a quick look to see if there's anything else interesting. Here's one where the plaintiff had a shoulder and neck surgery after a crash. And what happened was there was a verdict. This is also from the Bronx. There was a verdict for the plaintiff. It was an $835,000 verdict, but it says the actual award was $975,000. And it was a July 18th, 2025 trial. The plaintiff used orthopedic surgeon as well as actually 2 different orthopedic surgeons. And the defense used a biomechanical expert, as well as an orthopedic surgeon and a radiologist. And so just briefly, this happened September 28th of 2018. The plaintiff, he was 35, and basically he attempted to move, the defendant was driving a truck owned by Bronx City Recycling, and he attempted to move into the left lane, and his truck struck the rear quarter panel of the SUV that the plaintiff was driving. And so the plaintiff moved for summary judgment. The lower court denied it, but the appellate division reversed and gave summary judgment because it's a rear end. And then the injury was a C3-4 herniation with chiropractic treatment. And then there was arthroscopic shoulder surgery, partial labrectomy, and other surgeries to the shoulder, but there was also a discectomy and fusion at C6, C7. So pretty serious surgery. So the jury determined that the plaintiff sustained a significant limitation, because in New York you have to show a serious injury in a car crash, right? If you don't show serious injury, you get nothing. So he overcame that threshold. The jury found there was a significant limitation of it's the legal language is of a use of a body function or system, and there was also a permanent consequential limitation of use of a body organ or member. And the jury awarded the plaintiff $835,000. It was $500,000 future pain and suffering, $335,000 past pain and suffering, for a total of $835,000. It was a 2-week trial. It was 6-0 on the no-fault question, 5-1 on damages, 2 men, 4 women. And following the trial, the parties agreed to settle the case for $975,000. So the case was resolved. It doesn't say why they settled for more than the verdict. Maybe there was some kind of interest. Oh, probably interest, right? Because he had summary judgment. So probably the interest from the summary judgment made it higher than $975, but they just took the $975 to get rid of it, not to appeal and not to fight over the interest charges. So yeah, these are some of the cases. I mean, I'll go through a few just briefly. Here's another one out of California, Sacramento, for $1.15 million. And that was like actually a bad faith case where benefits were not paid. And there's another one for $250,000 out of New Jersey, where a motorist ran a red light. There's one out of Brooklyn, a settlement where a bicyclist was struck by a sanitation truck, and the settlement was actually $5 million. So a really good result there. And we could, do other videos where we go into depth on all these. But basically, and here's one more out of New Jersey for $450,000. But you kind of see like New Jersey tends to be like 300, 400. Texas was kind of low, 150, 200. California seems to be high. New York seems to be high. And I'm sure there are a few from other places as well. Yeah, so that's basically like a summary of what I'm seeing, just the most recent ones. And then if we go back a few more cases, we get into, we're still in like June of 2025. So we're still fairly recent. These are all from this summer. Okay. So please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone. And if you need a private consultation about your case, just text me. It's 347-566-9595. All the best. Bye-bye.